Okay, are we?
We are live, we are
Okay.
recording, and our attendees audience is populating right now.
All right. Let's see, how do I? Participants, there we go. Okay. All right, I will call the October meeting of the California Law Revision Commission to order. I think the first thing before we do the minutes, I just wanted to, I know all the commission members know it, but acknowledge that we have a new member from appointee from the State Assembly, Assembly Member Ash Kalra from Santa Clara County. Not sure that he'll be joining us today, but he will be a member in place of Ed Chow, who is termed out from the State Assembly as of the end of next year. So wanted to both thank Ed for his service and welcome Mr. Kalra to the commission as well. With that, I think the first order of business is approval of the minutes from the September meeting.
I move to adopt the minutes.
There's a motion. Is there a second? Been seconded. Brian, if you could call the roll to approve the minutes.
I will. Carrillo.
Aye.
Rivas.
Present.
We're calling the roll on approval.
Oh, aye, sorry. Aye.
Jenkins.
Aye.
Victor King is absent right now. McAllister.
Aye.
Miller O'Brien.
Aye.
Simpson.
Aye.
Minutes are approved.
Minutes approved.
Yep.
Administrative matters. Brian?
Yeah, regarding Assemblymember Chow leaving the commission, as soon as I heard that, I sent him a personal note thanking him. He was a great commissioner as our legislative member. And I was just wondering if, in addition to the chair's expression of appreciation, if the commission would like to put something in the minutes thanking Assemblymember Chow for his service.
I would certainly think that's an excellent idea.
Okay, I'm not going to take a roll call vote on that. Commissioner McAllister, did you have a question?
Yeah, no, I just wanted to say, I think it would be appropriate for the chair to send a letter as well as something reflected in the minutes to thank him for his service, if that's appropriate and other commissioners agree.
Sure.
Everyone agree? Okay.
Sure.
Okay, thank you. Commissioner Rubin let me know he will not be here today, so we're not expecting him. I am expecting Commissioner King. I don't know. He's apparently been delayed. I have not gotten an email from him, so I expect he's probably just got some temporary conflict, and we'll see him later. I am the single survivor of the incredibly shrinking staff. Steve let me know that he had a conflict at the last minute. It's not a crisis, but he's not going to be able to be here today. And both Barbara and Kristen continue to be on scheduled leave.
All right.
So I'm going to present the fish and game item today when we get to it. But yeah, I'm it.
Barbara's on her sojourn in Spain or something, isn't she?
Yeah, she'll be back quite soon. Yeah. I've heard from her a couple of times and it's gone well.
Oh, that's great.
I'm enjoying it. Yeah. As we've discussed before, there are 3 commissioners whose terms ended technically on October 1st. That's Commissioner Cubas, Miller O'Brien, and Rubin. And I believe that Commissioner Cubas has applied for reappointment and that Miller O'Brien and Rubin have not. And either way, you're eligible to continue to serve for a 60-day period after your end date. So Crystal, I hope we'll see you at the November meeting too, and hopefully Richard as well.
Yeah, I know they're working on it. I'm in contact with the governor's office, but I know they're working on a new appointment, but yeah.
Administratively, I'll want to inform you the state has adopted a new remote work policy. that applies to all agencies, including ours, which is aggressively promoting telework where it is feasible to telework. And there are a bunch of administrative steps that we need to take to get that all in place. But the short answer is that it seems very likely that our entire staff will continue on some telework basis even after the health measures relax around COVID. We'll see how that goes. I mean, we've been doing it for a year and a few months without any terrible fallout. And the state's eager to try and realize some savings by closing office space and reducing highway trips and that kind of thing. So just to let you know. And then the last item for this report.
David?
Yes, Commissioner Freer, you're there.
Yeah, on that subject, any movement on public meetings continuing to meet remotely?
Not beyond what I mentioned at the last meeting, which is that there was a bill enacted this year with immediate emergency effect that removes obstacles to that and is set to sunset on January 31st of January 30th of next year. And I don't know what's going to be put in its place. We'll see. But we're good for the rest of the year. And you know, Commissioner King had asked for periodic updates on the work of the Committee on Revision of the Penal Code. The most important thing I can say is that they had a successful legislative program this year. They got 7 bills enacted. They are using a more streamlined deliberative process than we use. They don't actually propose language for their recommendations. Instead, they propose like sort of the essential elements of a policy change, and then they work with authors and with the Legislative Counsel's office to draft implementing bill language. And so they're able to move more quickly than we are, but they have less control over the final product than we do. So a good first year for them. And we are in the process of hiring a new attorney for them that was authorized in this year's budget. That's all I have to report for the Executive Director's report.
Okay, thank you. Any suggestions from commissioners? Hearing none. Legislative program.
All our bills passed.
Yeah, I saw that.
That's it.
Yeah, that's it.
No new changes required, comments or anything. They all got signed.
Good.
So a good year for us too.
Good job, everybody. Yeah, yeah. Well done.
And I don't have anything to say beyond that. There's no decisions required for that item.
Got it. Okay, that takes us to Fish and Game Law.
Yeah, okay, thank you. And I do see that we have an attorney from the Department of Fish and Wildlife present. Thank you. This is Memorandum 2021-49 and 50.
Mm-hmm.
And following our recent practice in this phase of this study, 49 is a document that discusses changes that were proposed in our tentative recommendation that have been commented on by, in response to the tentative recommendation, comments by both the Fish and Game Commission and the Department of Fish and Wildlife. And we're taking a fairly conservative approach in this phase of the study where we are essentially proposing technical reforms where there is consensus among the commenters and where the staff doesn't have any new reservations as a result of reading the comments we received and our own sort of refresh on the material. So this Memorandum 49, as with other memos in this series, consists entirely of consent items. And so we can discuss any of the content that's in the memo, or if everyone is satisfied with the consent proposals, we could move the whole memo for approval of those items en masse.
Got it. Well, if Steve was here, I said before we started, I was going to give him a hard time about the Dungeness crab trap limits. But since Steve's not here to defend himself, I won't do that. Other than that, Are there any commissioners who have questions or comments about any of the content of Memo 49? Hearing none, seeing none. Brian, would this be an appropriate time to see if our attendee from Fish and Game would like to say anything?
Ms. Donlin, if you're interested in
Yeah.
commenting, you could raise your hand.
Yes, there it
Okay,
is.
I will allow you to talk. There you go. You're muted still, though. There you go.
Ms.
Okay.
Dahlin, welcome.
Can you hear me?
Yes.
Okay, hi, thank you. This is Angela Donlin with the legal office from Department of Fish and Wildlife. We have been working with Steve this morning, actually very early, sent him a spreadsheet of responses on about 50 items where he was just confirming that he had portrayed our comments correctly. And the answer in almost every case was yes, that he'd portrayed all of our comments correctly. We had 2 or 3 items where it was just a small adjustment, but not a big deal. We're continuing to do that, working with each of the comprehensive memos that you guys put out. So it's just kind of an ongoing process. And then I know Steve has set up probably 5 to 10 conference calls with various attorneys in our office to go over what you guys are referring to as the category 4 items. Those are items where it still requires some discussion for us to kind of all get on the same page. So I, thank you very much for all the work. It's a ton of work that he's, putting in and our attorneys, but, it's proceeding and I'm not sure that we're keeping up with your pace, but we are, getting through it piece by piece.
Great. And we thank you for your assistance and insight on this as well. It's been, I know Steve appreciates it and we all do. Thank
I
you.
would say that, that's what she described there sort of reveals that the memo's relative simplicity on their face is a bit of an illusion. There's a lot of work that goes on under the surface to bring you these memos that are vetted well enough for them to be presented as on a consent basis.
Right.
So are you ready to make a motion on the memo?
Unless any other member has question or comment? Seeing none, sure. Is there a motion to approve the contents of Memo 49?
So moved.
Moved and seconded
Second.
by Jane. Brian,
Yes.
call the roll, please.
Carrillo,
Aye.
Kubas,
Aye.
Jenkins,
Aye.
Commissioner King's still absent. McAllister,
Aye.
Miller O'Brien.
Aye.
Simpson.
Aye.
Thank you.
Great.
Memo 2021-49 is just a sort of an informational memo. We're building this cumulative document that reflects the decisions made at prior meetings just for ease of reference. And so there are no actions required for that item.
Right.
So I think that finishes this agenda topic.
Okay, terrific. That then moves us to the last topic on today's agenda, which is the stock co-ops and uniform TOD. Ryan.
Yeah, and this is the main event today.
Yeah.
And I see that we do have someone here from Texcom, a couple of people at least, but one I know might be interested in speaking as this discussion proceeds.
Okay.
And so I'm going to promote John Anderson of Texcom. He's been our very helpful liaison for the last year at least. And John, you're going to be able to speak as we discuss this as the chair recognizes you.
Great.
Thank you.
Great.
Good morning, commissioners.
Welcome. Okay.
So this is Memorandum 2021-51. And I was conflicted as to how best to present this. This is just to give the background. It's the discussion of the public comment we received from Texcom on our tentative recommendation to create a law that would allow the owners of interests in residential stock cooperatives to transfer their interests on death using a form instrument outside of probate. This study was a spin-off from the revocable transfer on death deed study, follow-up study that we completed in 2019. When the legislature directed us to perform that follow-up study of the efficacy of the revocable transfer on death deed statute, they also included some specific questions that we were to answer. And one of them was specifically whether or not the revocable transfer on death deed statute should apply to stock cooperatives. And in part, that was because the original enactment of the RTOD deed statute, for reasons that were never clear to me, wound up providing that only condominiums were eligible for transfer using the RTOD deed with regard to property that's in common interest developments. So common interest developments is a broad class of property where you have a separate ownership of an interest coupled with joint ownership of common property. And condominiums is one of 4 varieties. And it wasn't clear why they decided to limit it to condos. But when this was referred to us, we were specifically directed to consider whether it should be extended to other types of CIDs, including stock cooperatives. We recommended against applying it to stock cooperatives in the recommendation that was enacted just this year, mostly because stock cooperatives are different from other kinds of real property in that your ownership is not represented by a deed, and you do not transfer ownership using a deed. And so the commission was unsure what the implications of that would be if we use a revocable transfer on death deed to convey an interest that's evidenced by a share of corporate stock rather than a deed. And so the commission recommended against applying it to stock cooperatives, but in the same document expressly promised that we were going to come back and look at this issue and see if there was a way to allow for stock co-op owners to also have something similar to the RTOD that would allow for simple conveyance of their ownership interest on death outside of probate. And originally we conceived of it as possibly being something that could be done under an existing statute called the Uniform Transfer on Death Security Registration Act, which is a TOD statute, non-probate transfer statute for stock. And since stock cooperative ownership is expressed through the ownership of the share of stock, we thought, maybe this statute already applies to stock cooperatives. And we should look at it, see if it does, and see whether there need to be any adjustments to reflect sort of the peculiarity of this form of stock as compared to all others. So we launched that study, and we originally, like I said, we were looking at whether this is something that could be achieved through modification of the Uniform Security Registration Statute. Pretty early on, I think we realized that there was too much special law that would need to be applied to stock co-ops to shoehorn it into this other act, especially because the other act is a uniform act. And it would be sort of, it would undermine the value of uniformity to make such significant substantive changes to that statute. So we started instead drafting a standalone statute for stock cooperatives. We could have, at that time, instead decided to try and graft the stock cooperative law onto the existing revocable transfer on death deed statute. And credit where it's due, that actually was what our staff attorney, Steve Cohen, recommended to me at the staff level. And I was hesitant to take that approach because I thought that when we drafted this statute that it would be more different from revocable transfer on death deeds than similar to them. And so the differences would predominate and it would make sense for it to have its own statute. As it turns out, one of the things that's discussed in this memo is that's not how it shook out. In fact, the similarities predominate, and there aren't very many differences that need to be accommodated. So we could have early on decided to draft this as a graft under the RTO-DD statute instead of what we did in the tentative recommendation, which was a standalone statute. But that's where we wound up. That's the document we circulated. And so now we have a letter from Texcom with some specific general and specific concerns about the proposed law, and this memo. And in the memo, I worked through the specific general and specific concerns that Texcom raised. And in the process of analyzing them and thinking about them and coming up with possible solutions to the concerns, I felt myself drifting further and further away from sort of the underlying structure of the proposed law in some fairly significant ways. And so as you saw when you read the memo, I propose a possible restructuring that is both substantive in a couple of significant ways, but also technical in how it's expressed. And I did not make a recommendation as to whether or not we ought to adopt that alternative approach, in part because it's so new to me. It's a significant change from where we were. And I wanted to have an opportunity for the commission to chew on the idea, informed by input from Texcom before we decide or lean towards making such significant changes. Like I said, I was unsure how to best present this memo because there's sort of entanglements between some of the specific issues and the more general alternative proposal at the end of the memo. And so I wasn't sure whether to start with the specifics or start with the general and work backward. I think I'm just going to go through it front to back in the order that it's presented in the memo, and where something has relevance to the general alternative discussed at the end, I'll just flag that. Which is sort of what I did in the memo, and I think it's probably the best way to wrestle this material and get to where we're ready to start making decisions. So the first Texcom's general observations is they weren't sure that there is a sufficient need for this statute to justify it. And I get the sense that, justify the commission's efforts, the legislature's efforts, and the resulting complexity of the law. And they talk about the fact that there are only approximately 30,000 stock co-op units in California. And as drafted, the proposed law is optional at the election of the stock co-op. So it's likely to be far fewer than 30,000 would be eligible to use the statute because their stock co-ops decide not to opt in. My general take on that is there are policy reasons, policy considerations that might weigh in favor of not providing this legal framework for stock co-ops. And there might be technical operational reasons for not providing this for stock co-ops. In terms of the policy reasons, I don't see any. I haven't yet seen a reason why the law should allow all residential property owners to use an RTO-D deed, but not give stock co-op owners a similar mechanism. I think if there are reasons not to do it, they're operational reasons. It's just too hard, too risky, not worth the effort, that kind of thing. But in terms of straight policy, I think we ought to provide these property owners the same opportunities that other residential property owners have, unless there's some operational consideration that outweighs it. So that's a starting point. There's also this issue about the statute being sort of too complicated to be justified by this level of effect. And the complexity is sort of evidenced by the fact that it's a whole statute with over 50 sections, and they are complicated sections, etc. And two things I have to say about that, probably more. But first, I don't think that that's a good way of thinking about the complexity of this law, because, as I said at the outset, most of the provisions of this law are effectively identical to the RTOD deed statute. When we started drafting this, we were expecting the opposite result, but we drafted it so that where there had to be change, there was change. Where there didn't have to be change, we paralleled the RTOD deed statute. So in fact, if you look at the draft that's attached, there's just a few provisions that need to be different. And the rest of the statute is essentially just duplicating RTOD deed statute language. So I don't think it's nearly as much law as it appears to be. So that's the first thing I would say. And the second thing I would say is my experience working with bills in the legislature is that, appearances matter, first impressions matter. Oftentimes people will argue against legislation using sort of tropes like ain't broke, don't fix it, or a solution in search of a problem, that kind of thing. They do that because it's effective. That fits and evokes a general understanding of the proposal that legislators are familiar with. I mean, they do see bills that aren't worth the effort. And so these sort of shorthands, I think, have a lot of effect. And I anticipate that if we continue to have this proposal framed the way it was in the tentative recommendation with like approximately 50 code sections, we're constantly going to have to be answering concerns that the statute's too complicated. When in fact, the new substantive law is modest and not that complicated. And so that's one of the things that set me thinking about flipping the drafting approach that we used from a standalone statute to a tweak of the RTOD deed statute, is that I think that it would be a lot more successful in the legislative process if it is seen, I think, correctly as a minor modification of existing law, as opposed to an entire Rube Goldberg machine that we built to do not very much stuff, right? So that's part of what led me to the alternative drafting approach. And then the other thing I would say is that 30,000 people is a small fraction of the total housing stock in California, but it's not a trivial number of people. And it's probably billions of dollars worth of real estate. And I think if we can, through a tweak of the existing statute, provide an important estate planning alternative for the owners of that property, that would have a significant effect over time. And in terms of the effort involved to enact it, we've already done most of the work. So, I mean, you don't want to fall for a sunk cost fallacy, but we've already done most of the work. It's pretty much close to ready to go. And if we flip the drafting approach, it'll be relatively easy for the legislature to consider. Consultants in the committees will be able to zero in on the points of difference between this and the RTOD deed statute and do an analysis that's not that difficult, as opposed to getting a bill that has 50 code sections and they have to read all of them and think about them. So I'm not discounting the question that TexCom raised, but I think that my recommendation is that it's not a sufficient grounds to abandon this project, but it may well be a good reason to flip to the alternative drafting approach that's attached to the memo. So I'm going to put a pin in that decision point, as I will many others, because I'm trying to just work through sort of the genesis of this idea and how each of these individual decisions sort of led towards it and relate to it. The next general concern that TexCom raised in their letter was that And they frame this as basically being the same concern that they had about the RTOD deed statute for many years and continue to have, which is a general concern that the disadvantages outweigh the advantages. That creating a mechanism for lay people without the benefit of counsel and without judicial supervision to transfer the ownership of their homes on their death through a simple form is just too risky. It's too likely that there's going to be mistakes or bad acts involving fraud or undue influence, etc. And that it sort of invites that, and that the harm that's going to flow from that is going to be greater than the benefit of giving everyone a more affordable, straightforward way to do this. My answer to that in the memo is that's a critique of the RTOD deed. There's nothing about the stock co-ops per se that heightens that risk or presents it in a substantively different way. If we were to expand the stock co-op statute to, the RTOD deed statute to stock co-ops, we would be expanding the universe of cases in which that risk would be present, but we wouldn't be changing the character of the risk. And the legislature, on the commission's recommendation, just this year reaffirmed that California has an RTOD deed statute. And we recommended a 10-year sunset, a new 10-year sunset on that statute. I think the bill would have been approved by the legislature without that. And so I think that while I don't disagree with the concern that Texcom's raising, and we've certainly heard it from many credible sources, I think that the legislature has answered that question. And just this year, in the affirmative, that there ought to be an RTOD deed statute, that its benefits outweigh its disadvantages. So again, I don't see that as a reason to abandon this project. Now, before I get on to the specific concerns that Texcom raised, Mr. Chair, are you interested in giving John Anderson an opportunity to speak to the general ones?
Yes, but before that, I just want to see if there are any other commissioners who have any comments or questions about the general issues that you've raised. Yeah, David?
Yeah, I had a question about the direction from the legislature that's mentioned on page 2 of the memo. It says the legislature specifically directed the commission to consider this issue. Brian, what's your take on that? Is the direction from the legislature, we want to do this and tell us how you suggest we do that? Or is the direction, tell us whether you think we should be doing this at all?
I think when you say doing this at all, you mean revocable transfer on death deeds at all?
Yeah, this whole thing, like, is this a good idea?
Yeah, they definitely asked us that. When we did the follow-up study, the general question was, should the law be allowed to sunset, right? Should it lapse? And then there were some specific questions added on. If the statute were to continue, should it apply to types of common interest developments other than condos, for example?
So to me, it sounds like, and tell me if you agree, that it's an open issue, and the legislature would be interested in what we think about whether this is something that should be done or not. In other words, we don't have marching orders from the legislature. We want to do this, come back with a package on how to do it.
With respect to stock co-ops?
Right.
Yes, I would say that that's generally correct in the way they framed our original study. But in our follow-up study that we approved in 2019, the ultimate recommendation was do not amend the law to include stock co-ops at this time. But in the narrative part of the report, we explained that we would be doing a follow-up study of stock co-ops specifically. So while they said, yes, okay, we will continue to not have them be part of that statute, it was in the context of us saying, we will be looking at that and coming back to you with our conclusions about stock co-ops.
Okay. I guess I'm just trying to channel something that I've absorbed from Commissioner Miller O'Brien about, the role that this commission plays. And on the one hand, I don't want to be seen as the commission, not having done its homework. But on the other hand, I also don't want the commission to be in the position of recommending something that just is going to have no traction at the legislature. So I'm just wondering what the direction is from the legislature.
Well, they're expecting us to look at how to do this.
Okay.
Yeah, and then also to just make comment, with the studies, practitioners look at these studies and they look at the reports and they look at them long after we've ever touched them and completed them. And I just say that just on the practice side, some of the work that the commission has done on this topic and charter schools, and I'm just thinking with even other types of different liabilities, civil liability procedure. I know that in the firms that I've worked for, we've looked at studies and sometimes it's the only resource for how the law has evolved or generated. So these are very important. They have a part that has more far-reaching implications than we even know, that we can even anticipate at this point, because it continues on and on and on.
I would add, Commissioner Creo, that when we made our follow-up recommendation on this particular point, we didn't argue any policy reasons not to give this power to stock co-op owners. We raised a technical operational concern, like how is this going to work when they hold certificates of stock rather than deeds? And so I don't think the record is as clear as it could be in terms of the legislature expressing an affirmative desire that it be extended if feasible. I think it was pretty clear that that was the commission's starting point. That especially in the context of when we were talking about extending to the other two kinds of common interest developments, planned unit developments, and I'm blanking, community apartment projects, something like that. Our conclusion was, yeah, why not? I mean, there's nothing special about common ownership of common property that argues against allowing people to have the RTOD deed. The only reason we didn't extend it to stock co-ops as well is because we were concerned about the technical practicability of using that device. And we recommended, don't do it yet, but we're going to study it and we'll come back to you. So I think that's where we left it with them.
Thank you. That's helpful.
Mr. Anderson.
Yes, thank you. So as to the general issues, I don't really have any disagreement with anything that Brian explained so far. As to our principal concerns, the first one being that the complexity of the statute might have been too great, considering how few relatively how few stock cooperatives there are in California, was not necessarily did not reflect a policy choice on Texcom's part. In other words, we're not suggesting that if there's going to be an RTOD deed program, it shouldn't extend to stock cooperatives. I think the concern was more related to operational issues, as Brian indicated. And I would say, kind of generally speaking, we on Texcom kind of view ourselves in part as the, if you will, the protectors of the probate code. And so we like to keep it short and sweet if we can, and not so that's, I think that was basically the gist of our concern on that issue. And as to the second concern about RTOD deeds in general posing potential risks for mistake that might outweigh their overall utility, frankly, Brian is right. That's an argument that exists as to RTOD deeds, and that was essentially stated for the record, because we've felt that way about RTOD deeds all along. And if an opportunity to comment comes along, then we're just basically reiterating what we've said in the past.
Got it. Okay, thank you. Should we see if there's anybody else on the
Sure.
Attendee list who wants to comment at this point? If so, raise your virtual hand.
Don't see anyone.
Don't see any, okay. Okay, and then, so then it would make sense to move into the
The specifics.
specifics.
Thank you. Okay, so one of the specifics, and this one, this is one of the instances where working through the analysis really changed the way I see the problem. And I wanted to get feedback from everyone because I don't know whether the sort of epiphany I had was peculiar to me and I'm seeing something that's not there. But the thing that's important about this point is that if I'm right, then it also applies to the RTOD deed statute. And when we develop a proposed law, we ought to go back and fix that as well. So here's the issue. One of the general problems addressed by the RTOD deed statute is what do you do if there's a conflicting dispositive instrument? So you've executed your RTOD deed correctly, you've recorded it, it's sitting there waiting to operate on your death. But there's another instrument that you also correctly and properly executed that would dispose of the same property on your death, a will, a trust, maybe a transfer on death, designation of a mobile home, I don't know. So you've got something out there that is in conflict with your RTOD deed. What result when you die? And the way that the commission originally proposed to deal with this was with a probate code section, I think it's 5660, if I'm remembering correctly, which basically provides this framework for deciding which instrument controls. And one of the key points is that an RTOD deed would control over any unrecorded instrument, okay, that's not of record at the time of your death. It also provides that if the other instrument is recorded and it's irrevocable, the recorded irrevocable instrument controls. If it's recorded and it's revocable, the later executed instrument controls, right? So that's the structure of existing law. The legislature just approved a commission recommended improvement to that scheme, which was to push the deadline for recordation of these conflicting instruments from death to 120 days after the beneficiary gives notice of the RTOD deed. So that's sort of lining up a lot of other provisions that we have in this statute that are all built around this recognition and the fact that there's already a 120-day period during which title insurers are not going to issue policies, because that's the window during which a contest can be filed and a lis pendens can be recorded, which would defeat a bona fide purchaser's title, right? So title insurers are going to say, until that 120 days runs, we're not issuing a policy because we could get surprised by a lis pendens being recorded. So the commission in its follow-up study aligned a lot of these other recordation deadlines around that 120-day period because we figured there's already a burden on marketability. Why not create a greater opportunity for these other interests to be affirmed? So this is one of them. We said, if you've got a conflicting instrument, you can record it during that 120-day period, and it'll be treated as recorded under this section, which deals with the priority of conflicting instruments. So you've got a revocable transfer on death deed and you've got a trust. Both of them purport to dispose of the same property. You die, and the beneficiary, under the statute we just recommended, beneficiary gives notice to the heirs, the decedent's heirs, that the RTOD deed exists. And one of the heirs says, hey, wait a minute, this trust should be given priority. Now, under former law, if they hadn't recorded it before death, they were out of luck. under our proposed reform, which will kick in on January 1, they could then run down to the recorder's office with their trust and say, hey, I have 120 days to do this. I'm going to record this, and now it's going to be preserved under 5660 because it's the later executed or it's irrevocable or whatever. It's now good. It's going to control, right? Whereas before it would have failed. But I've recorded it in this 120-day window. It's now eligible to be the controlling instrument under 5660. So the proposed law for stock co-ops has the same, essentially the same rule. It's got a different code provision in the tentative recommendation, but essentially the same rule, same scheme. Texcom had some specific concerns about that. One of them was a lack of sufficient certainty that will or trust is recordable. They point out that it's not typical, or certainly it's not universal, to have wills and trusts notarized. And that might be an obstacle. The recorder might say, no, we're not going to accept an unnotarized document for recordation. So that was their first concern. Now, in the memo, I point out that that's easily addressed, right? We could just add language to the statute that says, a will or trust, for the purpose of 5660, a will or trust can be recorded notwithstanding the fact that it is not notarized. Done. We've drafted around it. Will, trust, or other instrument. They also raised a different point, which was some people, perhaps many people, use a trust rather than a will, in part because it's a private instrument. It's not going to be disclosed publicly. And so they like the privacy that the trust affords. It's going to be privately administered outside the courts. And if you have to record your trust in order to preserve its viability, then you're putting the contents into the public record, and there goes your privacy. That's another legitimate concern. And the idea that I had and that I expressed in the memo when I first was thinking about this problem is, well, the purpose of this recordation is not to get the terms of the instrument into the public record. The purpose is to create record notice that there's a conflicting instrument that may have priority. And to create that public notice so that title insurers can rely on the record as containing all the information they need to determine the validity of the RTOD deed. So as long as they know that there's a conflicting instrument out there that might trump the RTOD deed, then they know to hold off on issuing a policy until the conflict is resolved. So the thought that occurred to me is we could, instead of requiring that the conflicting instrument itself be recorded, we could instead, under this section, say that it's sufficient to record notice of a conflicting instrument that purports to dispose of the same property. And you could construct that however you like, and you could require information about like the execution date so that you could figure out whether it's the later executed, etc. And for the purposes of giving record notice, that would be as sufficient as a lis pendens is when it's giving you notice that a contest has been filed, right? They don't record their pleadings to explain the basis for the contest. They just say, there's a contest. World, you should know that. And so it occurred to me, well, maybe that's a good approach. We could shift this to, instead of requiring recordation of the instrument itself, require recordation of notice of the instrument's existence.
Brian, generally you do attach, you can attach the document, but in the interest of making sure that it would be confidential if that was an issue, you could, I just did it. You can record parts thereof and redact. So you can still get around it.
Yeah. So thank you. So that was my first thought was, well, okay, we'll draft around this problem too. We'll just say record a notice rather than record the instrument. Privacy is preserved. We'll solve that problem that way. But that's when I that's when I saw this problem from a different angle, because I started to think about this as just the equivalent of a lis pendens, right? All you're doing is recording notice of a conflicting claim. And the law already provides this 120-day period of impaired marketability during which you can record a lis pendens and put the brakes on BFP rights. So what does it add to record either the instrument, the conflicting instrument, or the notice of the conflicting instrument? And that's what occurred to me. It's like, maybe we just don't need to have recordation at all with respect to conflicting instruments. If it's clear that assertion that a conflicting instrument should control would be procedurally expressed through a contest of the RTOD deed, then why not just use the contest/lis pendens process that's already in place? So let me walk through an example to sort of try and ground this. So let's say you got a revocable transfer on death deed. You've executed it, you recorded it, it's all proper, and it's sitting in the record. The beneficiary gives notice, the transferor dies, the beneficiary gives notice of the RTOD deed, and the 120-day clock starts ticking. Then another heir of the transferor has in their possession a will or a trust that was executed after the RTOD deed, and they know that under 5660, that's going to control. It's going to be given priority over the RTOD deed. How do they perfect that claim? Well, they go and they contest it. I don't know exactly procedurally, and maybe Mr. Anderson could explain this if we need to know the details, or if I'm missing something. But there would be some sort of court proceeding in which you would say, hey, wait a minute, that RTOD deed is trumped by this instrument, which should be given effect, right? And that could be viewed as a form of contest. So what you do at that point is you don't need to go down and record notice that the instrument exists. You go down and you record a lis pendens and you say, I am contesting this RTOD deed. That creates the same kind of record notice during the 120-day period that recording the instrument would. And so with respect to putting the brakes on the issuance of title insurance and protecting BFPs, the result is the same. But there's a reason I think, to prefer the alternative approach of relying on the contest/lis pendens process. And this is subtle, and so I'm going to try my best to explain it, but it's fine if people want to ask for further clarification. Under the existing contest/lis pendens provisions of the RTOD deed statute, if you don't record your lis pendens in time, so you haven't recorded it in 120 days, and the beneficiary sells the property to a BFP before you record a lis pendens, you could still record a lis pendens, but the BFP is protected now because you missed the window. You could still contest the RTOD deed. You would go into court and you would say, hey, here's this trust that was executed afterwards and under whatever doctrine's control, like interpretation of conflicting instruments, it should be given effect. And the court says, yeah, you're right. The trust should be given effect. The RTOD deed should not have transferred that property. But the BFP has protection, so we're not going to void the RTOD deed. Under the general contest lis pendens rules, you are not entirely out of luck in that situation. You can still enforce your judgment against the beneficiary and try to get a pecuniary award to offset the value of the property that they sold. So if the court agrees that the RTOD deed should not have been given effect, you still have a remedy. It may not work out for you, depending on what the beneficiary did with the proceeds of sale, but they may still have that money and you may be able to enforce your judgment against them and get the cash. You won't get the property because the BFP is protected. And that's necessary for the sort of the operability of the RTOD deed statute under the recording laws. But you still can recover from the beneficiary who wrongfully benefited from this RTOD deed that should not have been given effect. Okay, so that's under the general rules for contests. And that would be the same result if your argument was undue influence or fraud or mistake or whatever grounds for your contest. You could recover from the beneficiary rather than recovering the property itself. Under 5660, that's not true. The 5660 is this very mechanical, bright line series of rules on which statute or which instrument is given effect. And so if the other instrument is not recorded before the transferor's death, the revocable transfer on death deed is the operative instrument. Okay, so let's run through that same scenario. I have this trust in hand. I receive the notice from the beneficiary. I go, whoa, 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 I'm gonna go contest this. But I didn't get my lis pendens in time during the 120 days. And the transfer sold the property. So now the BFP is protected. And I prevail on the merits in the contest. The court says, yeah, that's right. Your trust should have been given effect. But by law, 5660A says the RTOD deed is the operative instrument. Sorry, you don't get to recover from anyone because your trust did not operate with respect to this property. Now, so I saw that and I thought, oh, that seems problematic. That seems unnecessarily rigid. I can see why we went that way originally because we were very concerned with the operability of the RTOD deed statute in a system that relies on title records and title insurance. So let's have some bright line rules conditioned on what's in the record. As I started to think about this, I thought this is even more problematic when you start thinking about irrevocable instruments. Read literally, 5660 says, an irrevocable instrument that isn't recorded is trumped by an RTOD deed. So you could have executed an irrevocable trust and provided that this piece of real property was in the irrevocable trust. And I believe that that means you no longer have the ability there may be some exceptions to crack open irrevocable trusts that I'm not aware of, but as a general matter, you no longer have dispositional control over that property. You've made an irrevocable disposition of it. This statute says if you later execute an RTOD deed and the irrevocable trust wasn't recorded, the revocable RTOD deed controls. And I, again, understand why we went that way in order to make sure that the system works in reliance on title records. But it seems problematic. And it occurred to me that we could avoid those problems by taking the alternative approach I discussed in the memo, which is just treat this as a contest. Take that irrevocability out, or excuse me, take that rigidity out that conditions the outcome on whether or not you recorded your instrument within 120 days. Just dispense with that and say, no, we're going to use the general rules and allow them to be applied even if you're late in filing. And you are not entirely out of luck. If you prevail, you can go against the beneficiary. And that's already how the statute deals with other kinds of contests. And so why not just treat conflicting instruments in the same way? So that's a lot, I know. And I did my best to explain it in writing. I did my best to explain it here, but I'm very interested to hear what people think about it.
Commissioners.
I think there are issues, Brian, because there are other laws that are impacted by whether your transfer is in a revocable versus an irrevocable trust. So that is, we don't necessarily want to treat the contest for each device the same. Also, litigating or recording lis pendens, that the reveal part in the papers, that's easy to work around. You can refer to pleadings that have been filed and then rely on those pleadings within the any type of contest to try to create a separate level of protection or privacy, because then the judge can hold the pleadings on the contest and the trust as an in-camera document, or you can redact it. The privacy is not an issue, but I am concerned regarding the tax implications, because if you time this right, we could create a whole new vehicle for fraud. So say someone dies at the end of the year and then you don't want to file taxes or have the tax implications on a gift. And then at the end of, for 119 days, you go, oh, look, let me challenge this or something. What happens then? Everything is skewed, and we've created a significant or a major substantive change in the interest of streamlining what the law looks like. So I am concerned with that analogy. John, did you have questions? I was writing notes while Brian was talking, but I'm still, or John, I wanted to hear your thoughts on the practicability of how this would work in practice.
Are you, yes,
Sure.
you're asking me, yeah. First of all, I should just preface my comments by saying that this has not been discussed at the TexCom level as a whole. So my comments are based on discussions between me and my TexCom colleague, Deanne Parker, who is, together we've been the ones tasked with kind of keeping track of this study and reading the memo. So our view, we like this proposed change fundamentally because it seems to, it basically, how can I put it? It puts the most weight on the intent of the grantor, right? We think that's what should control what the ultimate disposition of the property. And I think that this mechanism that the memo proposes does that. So from that standpoint, I personally think this is the right approach. In terms of how it would work in practice, I'm not a litigator, so I don't know the ins and outs, but I don't see this as being unduly complicated. Obviously, if there's an RTOD deed and there's no contest, then the 120 days go by and everything, the transferee can get title insurance and sell the property, no problem. If there is a contest filed within 120, well, if there is a contest and a lis pendens is filed within 120 days, then it's the disposition of that property is then going to be tied up in litigation. But ultimately, the idea what we would ideally like is for the intent of the grantor to ultimately control the disposition of the property. So but Deanne and I like this approach. So.
No, and that's good. You know what? And honestly, litigation is ugly, and there are all kinds of. It's difficult to try to anticipate how bad it could be and what you can, what you could do to make sure. The goal, honestly, is the grantor needs to get their estate in order. So
that's right.
That's the real deal.
That's right. And
the other thing.
Right. The other thing, of course, is that the will could be subject to contest. So, and probably, so it would be, could be a protracted situation trying to figure out which document controls. But
And maybe that is ideal, because then, Brian, it is nice because then through your eyes and looking at it in a very, like hot knife through butter approach where you're looking at what it reads like, the law should read simply. And what will happen in real life, that's what makes practicing or litigating its own animal. So it is true. The law should read clearly. I am concerned that it could create new issues, but we're looking at Texcom and then we'll circulate this for further review commentary. So it's
Yeah,
fine. I think
we'll bring a draft back with whatever we have. There'll be another meeting at least. And so another opportunity for people to see it in the flesh and let us know.
I think
So-
that's good.
Brian, I in terms of the sequence of events, this is not an area of public policy I've ever set foot in. If the RTODD is in existence and the person passes away and within the 120 days, if someone files, whatever it is, a conflicting instrument, does that suspend because what I was concerned about is I think what I understood the original proposal to be is if someone files a conflicting instrument or records a conflicting instrument within 120 days, that suspends the ability of the recipient to take ownership of the property, and the property itself could then become the property of whoever prevails on which instrument, as opposed to if it goes beyond the 120 days, your only opportunity may be like a cash something in lieu of the property itself. I wasn't sure under your alternative approach whether that distinction still exists, or whether whenever someone identifies or brings forward a conflicting instrument, it ends up being, well, you could get the cash at the end of the process, perhaps. I wasn't sure how that.
So
if I'm even stating the.
Under existing law, there are basically two paths. Okay, one is for conflicts generally.
Okay.
And if you file a timely list penance, record a timely list penance, you can void the RTO deed and get title to the property.
Okay.
If you're
that's a 120-day window?
It is as of
Okay.
January 1. Yeah.
Okay.
If you're late,
Mhm.
you can still try to enforce against the beneficiary and get the cash out of them.
Got it.
That's
Okay.
one path. The conflicting instrument path is different.
Okay.
If you record within the specified time period, all that does is place you into 5660 as a potentially prevail,
Right.
depending on the
That depends on
revocability.
the nature of the instruments. Okay.
But if under 5660 you wind up on the wrong side of the equation, you get nothing,
Right.
because you were late.
Oh,
right.
okay.
And that's the problem that I
Okay.
see, is that it was put in there not as a matter of policy, but as a matter of practicability. Like
Oh.
we had to have this interest be of record in order for the title insurance system to properly operate. But it comes at a cost, which is you're potentially going to wind up with nothing, even though the
Okay.
transferor presumably wanted you to have it.
Got
Right.
it. Okay. I appreciate
Now-
that distinction. Yeah.
And I have a question, if I may, that I'd like to direct to Mr. Anderson.
Sure.
It's my sense, general sense, not grounded in specific research that I've done, but my general sense that even under existing law, and I see that we're joined by Commissioner King, for the record, thank you.
Welcome. Welcome. Victor.
even under existing law, if you had a conflicting instrument and say it was later executed, so you've got this trust and you record your lis pendens in the 120 days and you've got this later executed trust, it's not self-executing, right? The RTOD deed is still there. You'd have to do something to perfect your title, maybe a quiet title action in reliance on 5660 to say, look, I'm the winner, I held title. But it's not going to be something that's going to be resolvable outside of the courts, because the beneficiary of the RTOD deed is going to say, yeah, but I don't concede unless they do concede and settle it. But if they don't concede and they say, yeah, your trust is, that's fraud, that's not proper, I still get the house, you're going to wind up in court. There's not going to, unless the parties agree through a mutual agreement to settle it, there's not going to be an automatic resolution of a conflict. And that's another thing that led me in this direction is 5660 tells you like what the statutory outcome of these various conflicts will be, but it doesn't provide a mechanism for enforcing that rule. You're probably going to have to go to court anyway, which means you're going to wind up in what is effectively a contest anyway. So why not just use the contest machinery? And am I correct in that assumption, John?
Yes, I think you are. I mean, I guess in theory, there could be a situation where a grantor legitimately executed an RTOD deed, forgot about it, and then legitimately executed a will. Both are indicative of the grantor's intent. There's no undue influence or fraud or anything like that. And then, you could say, okay, the latter of the two instruments would prevail. But I think in reality, from a practical standpoint, it's going to be much grayer than that. And you're going to have exactly the situation that Brian suggested, which is, you may have conflicting arguments of undue influence. The taker under the will is going to argue that the RTOD was fraudulent and vice versa. And it's going to wind up, being litigated in the courts for the court to decide.
If I may too, just also, I suggest that when you that don't have equity or property that doesn't have equity, then that also creates an issue, Brian, where it could be resolved very easily because there's no assets to go to court and litigate anything. So then people they can resolve things through stipulations by just saying, I know there was an RTOD, it doesn't mean anything, you can have it, or I'm giving it to you. So things don't have to necessarily end up in protracted litigation. And the mechanism is just through a regular good old stipulation that civil procedure just recognizes on its own.
Reading estate planning case law is a much less optimistic thing than what you've just described. All of the cases are people who would not agree, and we're willing to fight.
Those are the cases that get published. So there's a whole bunch of other stuff that doesn't work out.
And if they can agree by mutual agreement, great. But the basic point I was led to was, if this is going to be the functional equivalent of a contest anyway, why not just have the lis pendens mechanism take care of it and not require in 5660 this rule based on recordation of the instrument or notice of the instrument, which will lead to bad results sometimes because of its rigidity.
That makes sense.
Does any commissioner see it differently? Okay, so I'm going to put a pin in that too.
Okay.
Because that's the rule that's reflected in the draft I attached, is the alternative approach.
Okay.
That was a big one. Thank you. Texcom in their letter also suggested generally removing the recordation requirement for stock co-ops. In part with the logic that we originally had, that if you've got the involvement of the stock co-op as an actor in the execution process, that can serve as the sort of check against fraud and a validating process, because at the end of the procedure that we proposed, it's the stock co-op who's going to transfer the ownership of the certificate of stock. And if it's operating outside of the title insurance process, then why even require that the registration be recorded? And that was our original position. We thought we could dispense with recordation because we were going to rely on the stock co-op to administer the process. And then we learned, I talked to some people, realtors and title insurers and experts in residential co-ops, and learned that sometimes title insurance is required. And it tends to depend on whether or not it's a market rate co-op. There are by law these limited equity co-ops that where the purchase price and sale price are intentionally limited to a small fraction of their actual market value in order to enhance affordability. And often that price is low enough that people can come up with the cash to buy into those kinds of limited equity stock co-ops without getting bank loans. And in that case, if you're just doing a cash deal and you're not involving a lender, then there's nobody who needs insurance to protect their interests, title insurance. But there are also market rate stock co-ops, and those are really the functional equivalent of a condominium with respect to title insurance. If you are needing a bank loan in order to buy in, the lender's going to want title insurance to protect them and their equity in the property. So we found out, okay, so there are some unknown number, some unknown percentage. We could probably figure it out. I would expect that the market rates condos prevail, are predominant over the limited equity. But in any event, in a lot of cases, you're going to require title insurance. And so all of the assumptions that are built into the revocable transfer on death deed statute also apply. You need to have everything in the record so that the title insurers can look within the four corners of the public record and have the necessary confidence that they have all the information they need to know whether there's any potential problem with the title in order to issue a policy. And so the commission decided, okay, given that, let's backtrack and require recordation, just as we do with the RTOD deed. So a couple of things about that. One is, and generally, TexCom is saying, well, we still think rely on the stock co-ops agent to police the process is sufficient. We don't think you should require recordation. So a couple of things about the fact that the commission's proposal requires recordation. One is, I don't think we can get around it. For the reason I just said, if title insurance is going to be required in a significant number of cases, then you're going to need to have the information available for the title insurers. And I don't see a clean way in the statute to sort of bifurcate the rule and say recordation is required for market rate, not required for limited equity. In part because there may be situations where even in a limited equity, you still need lender financing to come up with the purchase price. So I don't know that it's going to track 100% on that distinction. And I don't see any other clean distinction to build into the statute. It would be messy and fuzzy. The other thing that occurred to me is, if we are requiring recordation, as the proposal does, then this policy logic that says, well, recordation is the involvement of the stock co-ops as a sort of procedural gatekeeper and sort of a guarantor of the legitimacy of the process. The need for that becomes lower if you require recordation. And I think TexCom is correct in pointing out that sort of seesaw relationship. They're concluding you don't need recordation because you got the co-op to act as the authenticator. my thought when I was thinking this through was, well, maybe if we've got the recordation, we'll tip the seesaw the other way. If we've got the recordation, we don't need the co-op. And a significant chunk of the complexity of the commission's proposal is built around the involvement of the co-op. There have to be rules in place for their involvement and their liability because of their involvement. And then also, because of that, we built in that this, like the Uniform Transfer on Death Security Registration Act, which relies on stockbrokers basically as the gatekeepers, we propose that this statute be optional at the election of the stock co-op, as the security registration is at the election of the stockbroker. You're not required to provide this service to your owners, to your certificate holders. That undermines the utility of the statute by reducing the scope of its effect, because some stock co-ops are going to say, no, we don't want this bother. We don't want the potential liability, even though the statute provides a liability shield. We still don't want it. And so if we were to tip the seesaw more towards the recordation model, which we're already requiring recordation, and away from the involvement of the stock co-op, then we could also get rid of the elective character of the statute. We take away the discretion of the stock co-ops to control whether this law applies to them or not. And so it would apply across the board to all stock co-ops. And it would also reduce the complexity of the statute. It would relieve the transferor of any obligation to track down an agent of the stock co-op, get their signature on the form. And a later issue that we talk about is the revocation. You have to get their signature on the revocation. Get rid of all of that by just making it basically grafted onto the existing revocable transfer on death process, and don't involve the stock co-op at all. They don't really have a stake in it in terms of controlling whether or not you can do this. So why give them that power? So again, that was my thinking based on the general objection that Texcom has to requiring recordation at all. As I said, I don't think we can dispense with it. I think that there's significant instances where title insurance is going to be required. So I think we're stuck with recordation as a process. And once you're stuck with recordation, then this other vista opens up, which is, well, why do we need to involve the co-op then? And so that's where I wound up with that. And that decision too is built into the alternative draft because it greatly simplifies the statute. It like strips away 2 or 3 code sections that were designed to accommodate the involvement of the stock co-op. Does anyone have any concerns or questions about that?
Commissioners, questions or concerns? Do we want to see if Mr. Anderson has comments on that?
I agree with this approach. If recordation is going to be required, then I think the simplification is preferred.
Got it. Okay.
And so this feeds right into the next issue, which was Texcom said that it should be easier to revoke a TOD registration that you've executed, properly executed. The statute, as in the tentative recommendation, says you have to get the stock co-op signature on the revocation form. The Texcom saying that's onerous. You know, maybe you're revoking and you're ill and you no longer have like all the like mobility or whatever. The issue is, why should I have to go track down somebody from the stock co-op when I want to revoke this? If
And this will take care of that.
This will take care of that. So I'm going to move on to the next point. Well, let me say one other thing. They also object to the capacity standard. The proposed law says that in order to revoke, you have to have capacity to contract, and Texcom wonders whether that's too high and it should be testamentary capacity. That capacity to contract is exactly parallel to the RTO-D deed statute. And I don't really see a policy reason for them to be different. And I also recall that when, during the years-long effort to get the RTO-D deed statute enacted, Commission originally proposed testamentary capacity as the standard for RTO-D deeds, and the legislature insisted that it be changed to capacity to contract in the process of moving those bills forward. And so I don't think we should argue for a different standard here. The legislature's already expressed its preference in the RTO-D deed statute that it be contractual capacity. I think the same is true here. I don't see any reason to change it. Okay. All right, another interesting point, which I hope will be easy to address. TexCom raises a question about this section, probate code section 21134, which is a special rule having to do with ademption. And ademption is what happens if you've got a testamentary instrument or transfer on death instrument of some kind that purports to dispose of property, but before your death, you get rid of the property. What happens then? And section 21134 is a very narrow special rule for ademption in a particular situation. And the particular situation is the transferor lacks decision-making capacity and the property was sold or encumbered by the person who is acting for them to protect their interests, like a conservator in a conservatorship. So I'm conserved, my conservator sold the property and I had executed one of these TOD registrations. What result? Well, under 21134, the general rule is in that situation where the protective person, the protector, sells or encumbers the property for the protected person, the beneficiary of the instrument of gift receives the pecuniary value of the gift from your estate, if any. So that's not the general rule for ademption. In general, the rule is ademption terminates the gift. But if the sale or encumbrance or other transfer of the property was done by your conservator while you lack capacity, this is a special result and the beneficiary gets the cash value of the gift. So TexCom says that's good, that's general law, that's existing policy. It's not sufficiently clear whether it applies to the proposed law for stock co-ops. And so my first thought was, well, if it's not sufficiently clear that it would apply to stock co-ops, then it's probably not sufficiently clear that it applies to RTO-D deeds either, right? Because the statutes are so similar and neither one has express language on this point. So they're identical in that regard. So I went to do some research to see if I could figure out whether it clearly applies. And I went to the part of the probate code where section 21134 is located. It's in a block of statutes that provide general rules of construction for the probate code for interpretation of instruments. And it looked to me like it would apply. And the analysis is in the memo. I looked at, there is a rule of application for provisions that applies by its terms to 21134. And that rule says that
Is that the definition of instrument?
no, it's part of it, but 21101 governs the application of 21134 and everything else that's in the same part as that. Unless the provision or context otherwise requires, this part applies to a will, trust, deed, and any other instrument. Well, deed, okay, that covers RTO-D deeds, probably. But what about any other instrument? That's when I went and looked at the statutory definition of instrument. It means a will, a document establishing or modifying a trust, a deed, or any other writing that designates a beneficiary or makes a donative transfer of property. So I think that would clearly cover, in my view, unless I'm missing something that's elsewhere in the law, it strongly suggests to me that this special rule 21134 would apply to RTO-D deeds and would apply to the stock co-op statute, absent some contrary rule, which I don't believe our statute includes. So having walked through that strictly statutory analysis and recognizing that maybe I'm missing something, because this is not, I'm not an expert, I'd be interested to hear Mr. Anderson's take on that analysis and whether it addresses their concern.
Sure. Mr. Anderson?
Yes, thank you, Brian. First of all, the concern was not one of, again, not a policy related concern, but more just a operational concern. And we raised the issue just to see if the commission thought that any changes were warranted either to the RTODD language or to the 21134. The one question I would have, Brian, I agree with what you said. The question is whether a RTOD deed, and this would apply to RTODD deeds as well as to stock co-op, so the same issue applies equally in both cases. Would this be considered a quote unquote specific gift? Because that is what 21134 refers to. And a specific gift is also a defined term in the probate code.
Right. And I did not think to analyze along that line of law. My intuition is that it should be understood as a specific gift, because my recollection is that specific gifts are effectively a disposition of a specifically identified piece of property rather than a general pecuniary gift, like half of my estate, a general gift like half of my estate, or the heirs shall divide equally, or something like that. Those are general gifts. But if I say my 1965 Corvette goes to Rick Simpson, that's a specific gift. And I think that given that this is an instrument that disposes of a specifically named piece of property, that the best understanding would be that it's a specific gift. But if Texcom's view is that that's not sufficiently clear, we could consider putting language in just to expressly state that for purposes of this code, the RTOD deed is considered a specific gift. We do have language similar to that in one of the provisions of the RTOD deed statute that has to do with if you voluntarily agree to have the RTOD deed administered, because there's like complications relating to creditor claims and who's going to have to pay the creditor claims, and you would rather not deal with the complexity of working with the estate to get a determination of your personal liability. This is one of the reforms that just got enacted. The law will allow you to simply say, look, I don't want to deal with that. Let's treat this as if it had passed under the will, and apply general probate law. And I believe, if I remember right, that statute says for that purpose, this is a specific gift. So I think the commission has already contemplated that this should be treated as a specific gift in that context. And if it would be helpful, we could consider just adding a general rule in the RTOD deed statute and here that, for the purposes of the probate code, which would include all of these general rules of interpretation, this is deemed to be a specific gift.
Kind of makes sense.
And I assume that would satisfy that particular interpretive question. Am I right, Mr. Anderson?
It would. Again, we're not taking a position on whether 21134 should apply or should not apply. That's the commission's choice. We raised the issue simply, in case the commission thought it was an issue that should be clarified.
Yeah, and I would say that, going all the way back to the first steps in this study, in the RTOD deed study, I think the general policy assumption was that RTOD deeds are will substitutes, and that probate law should apply to them in the same way as wills, except as any differences need to be made to reflect sort of the operational character of the RTOD deed. But on general matters of policy, established estate planning policies should control. And so, I mean, I think consistent with that, I don't see any reason why we wouldn't want 21134 or any other provisions that are in that part that control all estate planning instruments to be applicable here as well. Would you, when I bring back language in November, would the commission like to see a provision that just states for interpretive purposes that this be treated as a specific gift?
I think so.
Okay.
Any objection? Seeing none.
So I think that that is the last of the specific responses to the concerns expressed in Texcom's letter. So now the question is, do I go back and take the the proposed legislation and the tentative recommendation and sort of implement all of the provisional decisions we've just discussed in that standalone statute?
Or
Or do I do the graft approach that's attached to this memo, where rather than creating a separate statute, we just graft these decisions onto the existing revocable transfer on death deed statute?
Scrap them.
And this one, I'd like a motion and a vote, because this will include all of the preceding provisional decision points and the guidance on the specific drafting approach that I will need in order to bring you back with a draft of a final recommendation for consideration in November.
I would move that in November, or we just come back with you just graph the changes, because I think this memo and our time now helps to provide enough of a foundation for why the changes were made, plus Texcom's letter. So we should be fine with just grafting.
so grafting it onto the existing law.
Mhm.
So
Similar to the approach
the alternative approach that
that's
that,
attached to
Brian-
this memo.
Okay.
Yeah.
Is there a second? Yeah, okay, second. Okay. So we have a second. Any other comments or questions from commissioners? There are other people on the attendee list. Should we, before we vote, see if there are any comments? I don't know if they're part of Texcom or if they're other independent people who want to make some comments.
Well, I got an email from John this morning where he said that in general, he and his colleagues, not the entirety of Texcom, but those who were involved in reviewing the memo, like the alternative drafting approach.
Okay.
And so I don't want to take words out of your mouth, but John, I just wanted to confirm that that's correct.
Yes, that is correct.
Okay.
I think it makes a lot of sense.
And the other folks who are attendees, that's who they are?
If they are Deanne Parker and Ryan Zapanik, then they're part of Texcom.
I see Ryan, I see a phone number.
Yeah.
And
I
then
think
I see Melissa Miller-Henson.
I think Melissa is with the Fish and Game Commission,
Oh, okay, okay.
and Deborah is our staff.
Yes, got out with Deborah.
So any of the other members want to raise or any other audience people want to raise their hands to comment? Okay.
Seeing none?
Call
Brian,
roll.
yeah, call the roll, please.
All right. Carrillo,
Aye.
Cubas,
Aye.
Jenkins,
Aye.
King,
Aye.
McAllister,
Aye.
Miller O'Brien,
Aye.
Simpson.
Aye.
Okay.
You're looking very dapper there, Victor.
So that concludes that item. And let me just say, for sort of the historical record, this confirms that public comment can have a big effect on a tentative recommendation. That oftentimes the tentative recommendation survives the public comment without significant change, but sometimes, we make a lot of changes based on the input we get. That's why we go through the effort. And I think these are improvements, and I will bring you back language in November.
Great. No, I appreciate that.
And my thanks to Texcom for the very useful input they gave us. I think it's
Indeed,
helped a lot.
indeed.
Well, my pleasure. It was nice speaking with all of you, and Brian, appreciate your efforts and those of the rest of the staff.
Great. Any further business to come before the commission before we adjourn?
Nothing from me.
Seeing and hearing none, we are adjourned.
Thank you all.
See you all next month.
Thank you.
Yeah.
Bye.
Bye.
Just be safe.